Good morning. May it
Good
please
morning.
the court. My name is Kim Mello, and I represent Bank of America. I would like to reserve 2 minutes for rebuttal. In this foreclosure action, the evidence is undisputed that Mr. Hemphill executed a note and mortgage, that he made payments under the terms of the note for 9 years and then subsequently defaulted. Mr. Hemphill has never disputed the terms of the note and mortgage. What Mr. Hemphill does dispute in an attempt to avoid foreclosure is whether the initials on the first 4 pages of the note, which appear to be SLM, not SLH, were his. In essence, he testified at trial that those were not my initials. Because they were not his initials, he also questioned whether he signed the note, but he did admit that it was similar to his signature. It was based on this testimony that the trial court entered an involuntary dismissal of this case. The trial court made 2 pertinent findings. First, the trial court found that the signature was, in fact, Mr. Hemphill's. In fact, the trial court said, "I have no doubt he signed the note on page 5. Mr. Hemphill has not challenged this finding on appeal, and in fact has expressly admitted it in his brief. Second, the trial court concluded that there were indications that somebody else may have placed these initials on pages 1 through 4 of the note, and that created a question as to the note's validity. The trial court then applied the bursting bubble presumption found in the UCC and concluded that Mr. Hemphill's testimony alone essentially rebutted the presumption, and that the burden then shifted to Bank of America to prove the note's validity. It's that finding that was wrong as a matter of law and requires reversal. The bursting bubble presumption found in the UCC provides that signatures on negotiable instruments such as promissory notes are presumed to be authentic and authorized. It further provides that if the signature is found to be valid, the note at that point is essentially enforceable unless the defendant has some other defense that would preclude its enforceability. This is, of course, consistent with the law that essentially says if you sign a document, you sign a note, you're bound by its terms. Here, the trial court clearly found that Mr. Hemphill signed the note. The signature on the note was therefore found to be authentic and authorized. At this point, the trial court should have conducted no further inquiry under the bursting bubble presumption. The note was required to be enforced unless there was some other defense.
I'm not sure that's exactly the line of reasoning that the trial court engaged here, and in order maybe to cut to the chase, if I understand the trial court's ruling, it was really an evidentiary ruling that what you've provided is not an authentic copy of the actual noted issue, that you've got an authentic signature on a standalone blank page that's just a signature, and you've got 4 pages here, and whatever this signature page pertained to, I don't think it's to these 4 pages here for the reason that we've got different initials at the bottom as opposed to what this individual's initials would have been. Can you address that evidentiary issue? Because I'm seeing this more as an evidentiary issue as opposed to, kind of the way you're characterizing it.
Absolutely. I mean, I guess my original point was, the bursting bubble presumption, which the trial court relied on in order to reach whatever result he did, as an evidentiary ruling, just simply didn't apply to this case. It only applies to the signature on the note. And I understand, what the trial court's concern was he was looking at this and saying, look, this looks like SLM to me, it's not SLH, so I'm concerned that this note is not legitimate and I'm not going to be able to consider it in this case. But it really, the way I view this, and I understand the evidentiary aspect, but it really was a misapplication of the law, because at the point that the trial court made that finding, really what that finding was he looked at it and said, this note has been altered. There's been some alteration here of
No,
this note.
I don't, I'm not with you on that, and I guess I need your help to make me understand that. I don't see, this goes back to your argument, this is a forgery issue. It's not. It would be a forgery issue if you had SLH at the bottom of those pages, and Mr. Hemphill says, wait a minute, that may look like my initials, but it's not mine. Right, a forgery is when somebody tries to make it appear like an actual individual signature or initials or what have you. This is a case where this individual is saying, I don't know what those are, but not only is this not mine, but this doesn't even purport to be mine, right? SLM, you read it, it doesn't even purport to be the same initials. So it kind of brings it back to the evidentiary issue, I think, right?
Right, but I mean, there's really no question that this was the original note. I mean, the witness testified that it was the original note. There was, there was testimony in the record as to kind of the chain of custody, how it went to foreclosure counsel, and then foreclosure counsel filed it with the court. So, I mean, this clearly was an original note. I mean, you can take an original note and you can scribble all over it, but it's still the original note. It's still self-authenticating. I mean, these notes are, by law, they're self-authenticating. And that doesn't mean, once it comes into evidence, that you can't introduce other evidence challenging its authenticity, which is what they tried to do with these initials. But the ultimate question that has to be asked is, what's the effect? What is the effect of the fact that it's SLM, not SLH? And really, at that point, you have to look at the UCC and what the UCC states. And the UCC states that when there's some type of an alteration of a note, whether it's a scribble, it's the wrong initials, somebody else may have thought they were authorized to write those initials in, and they did after he executed the note, what is the legal effect of that? And when you look at the UCC says that unless there is some alteration that modifies the party's obligations, the note remains enforceable. And really, at the end of the day, that was the trial court's concern.
Well, let's let's change your hypo. Suppose on the first page it says cancel. Who's got the burden now? It remains who?
Well, I mean, if it says canceled, again, the bursting bubble presumption, I don't think applies, okay? So we're not getting to that burden shifting issue because the bursting bubble presumption, by its express language, says it applies to signatures. And all the cases, at least that I've reviewed, it applies to signatures. So if you have a note and it says canceled on it, the issue then becomes, what is the effect of that? Was this note canceled at some point in time? At which point you have to introduce evidence. I mean, if the defendant is going to take the position that that note was canceled and therefore not enforceable, he's going to have to prove it.
So the mere insertion of the initials have no impact on the terms. That's your position.
Well, he never challenged the terms.
Okay.
I mean, he's made payment under the terms of this note for 9 years. The initials would only have an impact if it modified the party's obligations under the note. And that is clearly what the UCC states. Because they want these notes. I mean, it'd be very easy then not to enforce these notes. I mean, if you're going to say any scribble, maybe somebody went in and put the initials in there. Okay, so they did. So what's the legal effect? And the Roseman case that I cited in the reply brief, I think really kind of hits these points and also goes to the point I think that you were getting at is this authentic? Is this not authentic? Kind of the threshold evidentiary, issue. And, in that case, the facts were essentially, you had an original note that had a blank endorsement on it, and you had a copy of the note that did not have the blank endorsement on it. There was, however, an allonge on both of those notes that was essentially duplicative of the endorsement on the original note. The trial court in that case involuntarily dismissed, finding I think this note's inauthentic. Not going to, as an evidentiary matter, I think it's inauthentic. Based on this discrepancy, I'm not going to admit it as evidence. On appeal, the 4th District essentially said, you know what? This discrepancy, it does not affect the note's authenticity, or enforceability. Doesn't affect it. And the reason why the court reached that result, was getting back to the point that I made, is that the court said it did not modify the party's obligations under the note. The note has to be enforced. There's no modification of the party's obligations. So the involuntary dismissal in that case was reversed. Another case that I think is really instructive is the Gallagher case. And in that case, really, essentially the same argument was made in this case, where they said, they looked at it and said, those are not my initials on the note. And what the court said, I mean, these were the words of the court. I mean, he said, so what? That doesn't make the note inauthentic. And the court went on to say he admitted that he executed these loan documents. I mean, and here in this case, not only did he admit he executed loan documents, he admits to the terms, he admits to the principal amount, he admitted it was an adjustable rate note, he admitted that he received mortgage payments, you know, he made payments under it for 9 years. I mean, how can you not enforce the note, find it that it's valid at that point in time? These courts are saying, look, it just doesn't make the note inauthentic. It is still the original note. There's nothing showing that this was not the original note in this argument that, well, because these were on his initials, all of a sudden it's not the original note. That makes no sense. It's still the original note.
Help me out. Did the bank present or proffer any evidence, independent evidence, establishing the authenticity of what it proffered as the note in this case?
The evidence that was, well,
other than the presumption that you're relying upon, was any testimony, any kind of evidence that this is what it purports to be?
Well, I mean, first to just kind of go back, I mean, it is self-authenticating. I mean, it's pretty clear on that.
Other than that,
but in addition to that, the witness did testify that it was the original note, and we also have, and I'm not sure if I can get I'm not sure if I wrote down the
where would I find that?
Records site.
Where would I find that in the record?
I can probably find it when I sit back down. I don't know that I have it on this outline. But she did testify that it was the original note. I mean, there was some issue. I think she also mentioned that it had the wet signature on it. He objected to that. The trial court sustained that because it mentioned that it had the wet signature on it, which, you know, because she wasn't an expert, I guess she couldn't testify to that. But she did say it was the original note, and there's also all the evidence in the record that shows how the note was transferred. The original note went to counsel, and then counsel eventually filed that original note. So, I mean, that's what we have. I mean, really, as a practical matter in these cases, because the notes are self-authenticating, I mean, I don't think anybody's like really preparing these witnesses to introduce other evidence. I mean, clearly, when you don't have a self-authentication issue, you're going to have to introduce this extrinsic evidence, but...
Authenticity was a pled affirmative defense in this case, was it not?
What was pled was that there was a question. Yes, it was. It was pled as a denial. I mean, but I mean, what was pled specifically, I mean, was the signature itself. I mean, candidly, I mean, I wasn't there, but I think this whole issue of the initials was kind of somewhat of a, you know, was a surprise.
How could that be? I mean, help me out. How could that be a surprise if you've got a pled affirmative defense that says we're challenging authenticity? I believe was there a deposition taken in this case? And was the issue of the initials discussed in the deposition?
It's not in the record. The deposition itself is not in the record.
My point is that, you know, I'm not sure that it really matters, but this doesn't strike me as something that's coming out of the clear blue sky, right? I mean, this is not a situation. So in terms of what you're telling me, well, we typically don't prepare these, I'm not sure that that matters at all, but to the extent it could matter, in this case at least, I'm not sure how it could.
Right, so I mean, I guess your concern is essentially, these initials were SLM.
Well, my concern is that you are asking us to revert, this is as I see it, this is an evidentiary ruling, and you are asking us to hold as a matter of law, it was an abuse of discretion for this court, for this trial court, not to admit a note that plainly has different initials on the bottom as opposed to the borrower's initials, and where the borrower in testimony actually disclaimed that, wait a minute, these aren't the pages that I initialed. And you want us to hold as a matter of law that that was an abuse of discretion, and I just need your help getting me there where I could be comfortable signing off on an opinion that said that.
Right, but I mean, I think that's because, I mean, the focus, I think, of the analysis is really, the authenticity issue, the threshold evidentiary authenticity issue. And my point is, and I don't mean to keep repeating myself, but that it was, in fact, self-authenticating, and then once there was this other evidence that was introduced, okay, then the issue became whether or not that note should have been excluded. And what these cases say is that when you have discrepancies, it's really not necessarily an issue of is the note authentic or inauthentic. It's what effect the discrepancy has on the note's validity and enforceability. And again, that's the Gallagher case, and that's the Roseman case. In the Roseman case, you had somebody that came in and apparently altered the note by stamping a blank endorsement on it, okay, after the foreclosure action was filed. Okay, so it changed the note. Right? It changed the note, changed the original note, and the court said that doesn't make it inauthentic. It just doesn't. You have to then get to the issue because it's still the original note. It's still the original note. Doesn't make it inauthentic. You have to then get to the issue, which I know I keep coming back to, but I do think it is the dispositive issue, which is what's the effect. The trial court found, you know what? You have to prove that this note is valid and enforceable. Well, I mean, based on the evidence in this record, the answer to that is clearly yes, of course it was valid and enforceable. Based on the fact that he paid on this note for 9 years, he never disputed the terms. I mean, if you had a note, for instance, it was a principal amount of $100,000, okay, and somebody came in at some point and they altered it and they made it, instead of $100,000, they made it $400,000. Does that make the note inauthentic? I don't think so. I think it's still the original note.
Ms. Miller, just a reminder, you're into your rebuttal time.
Oh, okay. Then I will, at this point, save my remaining time for rebuttal. Thank you.
Thank you, Ms. Mello. Mr. Stopa?
Thank you, Your Honors. May it please the Court. This is an appeal that turns on the standard of review. There's not a lot of case law on this, so I submit the standard of review is a bit unclear. I submit to the Court that the standard is simply competent substantial evidence. Was there competent substantial evidence for the trial court to conclude, as His Honor did, that the note that they relied upon was not actually the original? The answer to that is yes, so as a result you must affirm. It's that simple. Now, when I say the answer to that is yes, here's why. On page 380 of the trial transcript, my client testified, this is not the original note. Those are not my initials. I never used the initials SLM for any purpose. I didn't sign there. The original note is not in the courtroom. That was my client's testimony. That was competent substantial evidence upon which the trial court could rely in order to conclude.
Was there a signature on the note besides the initials? Was there actual signature on the note?
Sure. The judge did find that the last page of the note, which was otherwise blank, contained a signature on it. But he also concluded that that was not the original. And so I have And I submit that was entirely within the judge's purview. That's his job to make a conclusion on whether that's actually the original or not, a fact-finding. And let me give Your Honor a couple of examples. You gave one about canceled. Here's a couple examples that I've thought through. Suppose that a plaintiff comes into a trial and they try to introduce as the original a document that's clearly a copy. Anyone looking at it can see that it's plainly a copy, and they want to take the position, well, that's the original, you should introduce it as self-authenticating. It's within the judge's purview to say, I don't think this is the original. I think this is a copy. I'm not introducing this into evidence, and then without the original in evidence, the plaintiff loses. Or here's another example. Suppose that the plaintiff comes to a foreclosure trial and they have an original note, but it's not the note for that borrower. It's a totally different note on a totally unrelated borrower. It's within the judge's purview to look at that and say, this is not the original note for this loan. I'm not introducing that into evidence. In both such circumstances, there would be competent substantial evidence to conclude that that was not the original note and to affirm any appeal that emanates from an involuntary dismissal resulting from the original note not being in evidence.
So was there a count to establish a lost or stolen note?
Not at all. Not at all. And so, you know, the issue was not and should not have been a surprise to them. Here's paragraph 4 of our answer. Defendant denies and this was paragraph 4 of their complaint is the one where they refer to the note. So we have a specific denial where we deny the validity and authenticity of the note and all signatures thereon. So we clearly spell that out in the pleadings that we're denying the authenticity of the note and all signatures thereon, and we go to trial and testify this is not the original. Now, I thought it was interesting. Counsel kept saying so many times, it's still the original note. There's no question this was the original note. Your Honors, there was no evidence that this was actually the original. So not only did you have my client testifying this was not the original, from which there was competent substantial evidence it was not the original to support the trial court's finding, there was no evidence it was the original. And when Your Honor asked that, I couldn't help but note my opponent paused and then didn't have a record cite. Well, I have the record cite. Here it is. It's page 335. And when their witness tried to say that the original note has a wet signature, as counsel argued, I moved to strike that, and that objection was sustained. So there was no testimony that that was the original note, because here's how the trial unfolded. In the plaintiff's prima facie case, they moved to introduce the original note at the beginning without any evidence at all. There was no testimony about it at all. And I objected at that point. At that point, it was overruled, but the plaintiff rested its prima facie case, making no effort, no evidence, nothing at all to say that this is the original. There is nothing they can point to in this record that even indicates that this is the original. Nothing. Nothing. And that's why they had no answer to that question, because there's not going to be an answer, because there's nothing in the record that shows that this was actually the original. And what you have is my client's testimony is undisputed that it's not the original, and he didn't sign this. So, you know, and in the defense case, I also elicited testimony from the bank's witness. And I did something I frankly almost never do. I asked an open-ended question that allowed for a hearsay explanation. I asked an open-ended question that allowed for a hearsay explanation. Do you have any explanation for why the first 4 pages on this note say SLM instead of SLH? Answer, I don't. Even when I allow a hearsay explanation, she had no explanation for why SLM was on the first 4 pages instead of SLH. She also testified that she never saw the purported original before the day of trial. She never spoke with anyone at Bank of America or Wells Fargo regarding whether that was actually the original. And she had no documents at trial reflecting whether that note was actually the original note. This is not a fact pattern upon which you can conclude there was no competent substantial evidence to support the trial court's ruling. Or even if you think that the standard of review is clearly erroneous, which is what the Florida Supreme Court says when there's issues about authenticity. When you have documents excluded or evidence excluded based on authenticity, the Florida Supreme Court says in the Justice decision in 1983, cited in my answer brief, the standard of review is clearly erroneous. How could you possibly say on this record that it's clearly erroneous for the trial court to conclude that that was not authenticated, when they have literally nothing that they can point to? The only argument my opponent made was an answer that the testimony was stricken on page 335. They literally have nothing to point to in that regard. Under 673-3081, we clearly introduced enough evidence in order to overcome the presumption of authenticity. Now, mind you, I certainly think that a PCA and a fast PCA would be appropriate here. I also think it would be appropriate to write a decision explaining how the quantum of evidence was sufficient to overcome the presumption under 673-3081, only because there's so little case law on that issue, and that might be why they brought this appeal, because there's so little case law. And I had to go, we both had to go to cases in other jurisdictions, but the one I thought was telling was Carson Franklin, a New York case from 2016, that seems to summarize pretty well the cases from other jurisdictions on what quantum of evidence is necessary to overcome the presumption that a note is self-authenticating. And the way they explained that was it can't be based on mere speculation or conclusory assertions, but there has to be specific evidence from which the court could find that a reasonable juror could draw an inference that an endorsement is not genuine. A reasonable juror could draw an inference based on evidence that the endorsement is not genuine. That's the way they couched the issue in the Carson case. So applying that type of standard to the facts at bar, obviously a reasonable juror could conclude that this was not the original note when the first 4 pages did not have my client's initials. He testified that he did not sign that, and the bank had no explanation for why those appeared in that manner. So it's obviously up to your honors on whether you think that's something that's worth writing on, whether the quantum of evidence issue, that might be useful. A PCA I also think is appropriate. And as I thought about that reasonable juror standard, one of the things I thought about is sometimes some of these issues, don't come down to law or statutes, but could you explain this to a member of the public? Like, could you go home to a spouse or your children and tell them why you would be reversing on a fact pattern like this? Well, the first 4 pages had someone else's initials, and the bank didn't have any explanation for it, but we're going to conclude that that was the original note anyway and allow a foreclosure. To me, it just doesn't even make sense. So certainly a reasonable juror could draw an inference based on the evidence presented that the note was not self-authenticating. A couple other issues that I'll touch on. The correction agreement that my opponent tried to use for the first time in appeal as if to speculate and say, well, that the initials must have been put on afterwards by a closing out agent. There was absolutely no evidence introduced at trial on that issue at all, so that was clearly unpreserved. That's purely speculation, given the lack of evidence on that issue at all. There was no evidence that that was actually a typographical or clerical error as necessary for that agreement to apply. There was no evidence that Mr. Hemphill received a copy of the note after closing, which would be necessary for that agreement to apply. And all of that evidence was not, that correction agreement was not introduced in the plaintiff's prima facie case, as would be required under this court's decision in Day versus Amini. Your Honors, this was an 11-hour trial. It was the longest foreclosure trial I've ever had. The court went past 9 p.m. It carefully deliberated the facts and the evidence before it, and it came to a very reasonable conclusion that this was not the original note. There is no basis before this court to now reverse. This court should affirm. Thank you.
Thank you, Mr. Stopa. Ms. Mello?
May it please the court. I have 3 brief points to make in response. First, if this court is going to write anything on Section 673.3081, it should find that the provision just doesn't apply here. It applies only to signatures. It has no application to this case. He makes the arguments about how, there's all this evidence that, this was not the original note. Yes, Mr. Hemphill did state, they're not my initials, so I don't think this is the original note. That's entirely different than coming into court with something that looks like a copy. Then you've got an issue. Then you've got an issue as to whether or not it's the original note. That's not the evidence in this case. The trial court originally admitted this note because it was self-authenticating. At that point, he had to come up with some evidence showing it wasn't the original note. He had to meet that burden. Puts his client on the stand, and his client just says, those aren't my initials, so it's not the original note. It's not enough. It doesn't even make sense. You can scribble on the note, you can color over it, you can do a lot of things to a note. It's still the original note. It may be altered, but it's still the original note. Also, the Carso-Franklin decision that he relies on, it's it's inapposite to this case. I mean, in that case, there was specific evidence demonstrating that the blank endorsement was a forgery created after the fact to establish standing, and there were other evidence in that case of similar forgeries. There's no evidence like that in this case. That case specifically dealt with the application of the bursting bubble presumption that we've taken the position it doesn't even apply here. So for those reasons and the reasons that I have stated, we respectfully request that this court reverse the involuntary dismissal and enter a final judgment in Bank of America's favor. Thank you.
Thank you, Ms. Mello. Thank you both.